various references in the papers to the extent to which the Reserve Bank sought to place before the public protector a very extensive record of literature and submissions concerning the crucial role of the lender of last resort as one of the critical functions that the Reserve Bank discharges under its mandate. I shan't take up this Court's time with a recitation of that literature, but you will see it all captured in the covering letter that appears at page 186 as early as August 2011, when the Reserve Bank wrote to the public protector and sought to explain the fundamental importance of the role that the Reserve Bank plays as a lender of last resort. At the risk of greatly oversimplifying this particular role, it is fundamental to the bank's role that it ensures financial stability of the financial system. One of the risks to financial stability is that a bank, sometimes many banks, may run the risk of solvency problems. And the role of the bank in intervening in those circumstances is done in order to prevent systemic risk to the financial system. And that was precisely what was done in respect of Bank Corp. Now, the way in which this issue develops, both in the report of the public protector but also in the submissions that take place to the public protector, is that two debates are taking place. The first is the debate that I have already signaled, which is what is the role of the bank as a lender of last resort, and to whose benefit does that accrue? That's the one debate that takes place. The second debate that takes place, and it is much more a matter of the various bodies that have examined what precisely was done in respect of the assistance given to Bank Corp and thereafter to ABSA, but that debate concerns the modalities by which financial assistance was rendered. So the Court should keep in mind these two issues. Is there a proper role for the bank to play in being a lender of last resort? And the second issue, which is, in the particular case of Bancorp, how was that role discharged? Now, the first topic, as I've said, was the subject of extensive submission by the Reserve Bank because it considered it fundamental that you can't even begin to examine the second topic if you don't understand the fundamental role that the Reserve Bank plays as a lender of last resort. And what emerges from the literature, emerges from the submissions very clearly, is that it is a standard and perfectly well recognized feature of the role of central banks throughout the world that they will intervene for the purposes of securing liquidity in the financial system so as to prevent bank failure and the risks of systemic harm to the financial system. And that proposition, raised extensively by the Reserve Bank in its submissions to the public protector, but equally in the Davis report. And again, just to reference that for the Court, the Davis report is in the papers, it's in ABSA's papers, it commences at page 1245, and there is an executive summary with which it begins. But again, in order to simply try and summarize the critical observations that are made by the Davis report, it explains that the intervention that was made in respect of Bancorp was an entirely justified intervention in the interests of protecting financial stability. So the Davis report, a lengthy report, again looks at both of these issues. It endorses and says it was perfectly justified to intervene because a bank in trouble in an economy that was in significant difficulties was justified and warranted action in the discharge of the Reserve Bank's functions. What the Davis report then goes on to say, as others have said, was that the how question, what were the modalities by which the financial assistance was given, were, in the view of the Davis panel, not ones that comported with international standards, and various criticisms were offered of the modalities of the detail of the assistance given, but not the role of the bank as a lender of last resort, nor the reason that it was justified in this instance to have an intervention. And of course, the Davis report was provided by my clients. It was before the public protector. She had full knowledge of it and its import. What we then observe in the report that the public protector then renders is that she entirely misunderstands the first of these issues, whatever may be said for the second of them. And that you will find in, as the public protector's report is in the ABSA papers, but what the public protector has to say on this score, and it's a somewhat fractured set of reasoning in different places, but is to be found essentially at pages 136 and 138 of ABSA's papers, and in particular the paragraphs at page 138, paragraph 5.3.23 and 5.3.25 are indications as to how the public protector understood, or in our submission entirely failed to understand, the role of the Reserve Bank as a lender of last resort. So you will observe at page 138 of the ABSA papers, the following is said: "It is evident that the status of the South African Reserve Bank as the lender of last resort has commercial benefits only in respect of the financial sector market. The benefit, which involves vast amounts of public money, does not improve the socio-economic conditions of ordinary citizens of the Republic, but of a particular financial sector, At 5.3.25, it is this belief that once the state takes control of creating money and credit, numerous benefits accrue." And there then follow various findings, which are essentially that with that understanding of the role of the bank, the Reserve Bank as a lender of last resort, being a distorted form of intervention, there is apparently then cause for some of the remedial action that is required. Now, we say all of that because ultimately our complaint is this, that the public protector, having been given a full account of the fundamental role of the Reserve Bank within its remit to secure the stability of the financial system, then pursues this topic on a basis that simply is not one that she could reasonably engage, given what we say is fundamental to her role, which is the separation of powers doctrine. And what we have in mind is just this. The Reserve Bank is the specialized agency created under the Constitution to secure the financial integrity of our system and our economy. We don't say, simply for that reason, that the public protector can never investigate anything that the Reserve Bank does. But if the public protector is going to engage upon the question as to whether the very role to be discharged by the Reserve Bank as a lender of last resort is a fit and proper purpose for it to serve, then we say, given what has been considered by the public protector and what is operative in her reasons for making the remedy, or providing the remedies that she does, that she has trespassed over the line. And she has done so because she has arrogated to herself a consideration of what is a fundamental constitutional role. The Section 225 of the Constitution speaks to the fact that the Reserve Bank enjoys the competences that are customarily exercised by central banks. All the evidence before her shows that lender of last resort is a function customarily discharged by central banks. In trespassing into this field, in the way that the public protector has, she has trespassed over the boundaries between organs of state, and she has ventured views that are simply inconsistent with both the Constitution and the separation of powers, which is the important responsibility that the Reserve Bank has to discharge its function to secure financial stability as a lender of last resort. Now, it's true that the public protector appears to have been much attracted by exotic theories around Reserve Bank functions, Mr. Goodison and the like, and belatedly by utilizing the services of Dr. Mkhwebane. But none of that is relevant in respect of the complaint that we make. And boiled down to its essence, it's the following. In ventilating and taking the position that the public protector does as to the function of the Reserve Bank as a lender of last resort, the public protector committed herself to a position which is fundamentally at odds with the constitutional role given to the bank, and therefore she engaged upon an inquiry that violated the separation of powers. We submit that in her operative reasoning, she never disaggregates the two questions that the Davis panel was so astute to observe, which is, what is the function of the bank as a lender of last resort? And how has that function been discharged in the case of Bancorp? The public protector simply sees these two inquiries as being essentially so entwined that the remedy that is imposed flows from these two entwined forms of reasoning that the public protector engages. And because, in respect of the first part of the inquiry, the role of the bank as a lender of last resort and its fundamental constitutional importance to secure financial stability, the public protector strayed outside her competence. She engaged in reasons that were operative reasons for the purposes of the remedy that she ultimately imposed that is unlawful, that constitutes unlawful action. One can see some of this reflected both in our learned friends' heads of argument, where they come to deal with these questions, and again they simply repeat the very kinds of errors that we submit the public protector committed herself to by failing to observe the difference between what she might consider, which is whether there has been a proper exercise of a competence that exists, and traversing the question which is constitutionally entrenched, which is that that is a competence that is justifiably engaged by the bank, because that is a matter beyond her remit. And so she has erred, and it is an operative reason that vitiates the remedy that she imposed. Can I say one other thing, or perhaps make two other observations? One of the extraordinary features of the way in which the report finally reasons to its conclusion is that, having signaled this position quite wrongly and in violation of the separation of powers about the role of the bank as a lender of last resort. She, the public protector, then moves to remedial actions which never question the very consequences of the remedy that she is seeking to impose. One of the signal features of other bodies that have examined these problems is that whatever criticisms they may have come to of this long historical intervention by the Reserve Bank, they have always weighed very, very carefully whether intervention by way of remedy long after the event could give rise to the very harm that is sought to be avoided by the intervention in the first place. So when the SIU and the like looked at this problem, they understood the very grave danger of bringing into question and seeking remedial actions in respect of interventions of the Reserve Bank of this kind, because, and here is what is so fundamentally problematic about what the public protector has done, by calling into question this fundamental role of the Reserve Bank as lender of last resort, she has been a source of instability in the financial system, because that fundamental role of the Reserve Bank is now open to question by a high office of state in the public protector, and she is proposing remedial actions which will perpetuate that uncertainty through the remedies that she seeks to advance. And therefore, for both of these reasons, both because she has strayed in her questioning of the role of the lender of last resort that the bank has, and then followed it through with remedies that will perpetuate that very error in a way that is very problematic to the institutional integrity of the Reserve Bank and its fundamental role in securing financial stability in our economy, that cannot be allowed to stand. Because if it does so, it would perpetuate a view that fundamentally undermines the role of the Reserve Bank. And the belated efforts by the public protector to invoke Dr. Mkhwebane's views somehow as ballast for her violation of the separation of powers goes no further. All that she is doing is simply seeking after the event to support a view that she has that she considers this role to be problematic. Well, she may, but it's not the role of the public protector to do so, because it is a role, as I've sought to indicate, constitutionally mandated and entrenched. We therefore say that, on that ground also, there should be a setting aside of the remedial action that is required by the public protector. I want to, if I may, then move to the next topic. Sorry, there's just one. I should just emphasize one point. We have referenced a couple of cases in our heads of argument, and I shan't repeat what is said there. They simply affirm the importance of the separation of powers doctrine as a principle of restraint and deference that is necessary to the integrity of the different offices of state that exist. And we also do cite for the court the English case, the case of Askin, where again the question of the role of the central bank in ensuring financial stability is not some unusual or sinister encrustation in the Constitution. It is fundamentally important for the reasons that I have explained. So we would ask the court to bear those authorities in mind as the general principles that explain the basis of our objection to the report and the ground for review that the separation of powers gives rise to. If I could then proceed to the question of jurisdiction and just make it plain that I'm not going to cover ground that my learned friend Mr. Marcus has already dealt with. Here I'm going to deal with what we've styled as the fifth ground in our heads of argument at page 29. Our submission on this score is as follows. Section 6, subsection 9 of the Public Protector Act says this, and I'm now reading, it's reproduced at paragraph 64 of our main heads of argument. Except where the public protector in special circumstances within his or her discretion so permits, a complaint or matter referred to the public protector shall not be entertained unless it is reported to the public protector within 2 years from the occurrence of the incident or matter concerned. Now, the first proposition is this. One has to construe the nature of the power. We say, properly interpreted, it means the following. There is a rule, and the rule is the 2-year rule, which says the public protector shall not entertain unless it is reported within 2 years. Now, obviously, the rule is predicated on the usual basis, and the purpose of such a rule is predicated on the usual basis for time periods, which is certainty and finality. There must be a time after which the exercise of certain public powers come to an end, because we cannot have public powers exercised to repeatedly go over matters which have been looked at in the past, or even if they haven't been, are now beyond a time period when it is useful to engage the powers. That's the rule. But there is, of course, an exception to the rule and a power given to the public protector pursuant to the exception, and that has two parts. The first part is that there must be special circumstances. Now, the question is, the special circumstances have got to be special by reference to the rule. In other words, they must be out of the ordinary, because notwithstanding the ordinary incidence of the rule, there is something so special about these circumstances that it warrants not applying the usual rule. And so you have to demarcate on a clear and objective basis what those special circumstances are in order to trigger the exercise of the discretion. And then there is the third part of the provision, which is that if there are special circumstances, then the public protector has a discretion. But the exercise of the discretion clearly has to engage with the exception to the rule. So you cannot properly exercise the discretion unless you do three things. One, have a proper appreciation for the rule, the standard instance of application. Demarcate what the special circumstances are that are objectively established as a potential exception to the rule, and then explain how the discretion is to be exercised by finding that there is warrant to take this matter out of the ordinary application of the rule. Now, I've given a somewhat detailed account of this because nowhere in the report will you find anything that indicates that the public protector has properly appreciated how this discretion is to be exercised. In the report, one sees the manner in which the public protector exercises this discretion. And if I could ask the court briefly, if you have it to hand, to turn up page 105 to 106 of APSA's papers. At paragraph 3.22, there is a recitation of the relevant statutory provision, and then we see the following. The section gives the public protector the discretion to decide on whether to investigate a matter reported to the public protector's office, even if it is something that happened after the establishment or coming into being of the office. Well, actually, this rule is really about the 2-year rule from the of the date of the occurrence and the date of complaint. So there's nothing in what is said there which indicates any appreciation of what the discretion is and the circumstances of its application. And then all that we see that follows is whether the matter was reported to the public protector on 10 November 2010 is not a jurisdictional question, but one regarding whether there are compelling circumstances to warrant the public protector's discretionary power to investigate alleged improper conduct. I must say the logic of that sentence is not clear. But what is clear in what follows is the public protector applied its discretion and concluded that special circumstances do exist for necessitating a full investigation. But what are those special circumstances? No. What she, not in her report. In her answering affidavit, she attempts. But you've got to, in your reasons, explain, one, that you comprehend the power that you have, and two, that you explain the basis on which it is exercised. She goes on to say the matter has been in the public domain for some time, not certain why that is availing, and it was in the best interest of the people of the Republic that this matter be investigated and adjudicated upon. That is just tautologies. Of course, every matter that is of some concern could be investigated. That's even true of matters that fall within the rule, but these are just empty blandishments on the part of the public protector. And there is little more at page 106. All that is then said at 3.28 is that she recognizes that there's no jurisdiction to investigate matters that occurred before the office came into being. My learned friend Mr. Marcus has dealt with that. The public protector enjoys a discretion to investigate matters which occurred after 1995, more especially if the prejudice caused is still in existence and in addition the insurmountable public interest in the matter. We never see a coherent account as to how this discretion was exercised because, frankly, it does not appear that the public protector comprehended the nature of the power, the circumstances in which that power is situated as an exception to a rule, and how the special circumstances arise in this case, most especially for two reasons. One would have imagined, at a bare minimum, that given the extent of scrutiny which the transactions and the financial assistance has come under by successive bodies that have looked at it, Heath, the SIU, the Davis panel, at a bare minimum one would have thought, well, what more is there for me to consider, and why is it still current and warranting of further attention, and what are the consequences of engaging this inquiry at all? But none of that is to be seen. There's simply an assumption of jurisdiction because there is a desire to exercise jurisdiction, and that is simply not a proper basis for doing so. In the answering affidavit, and I don't need to take the court to it, but it's at pages 19 to 21 of the Public Protector's record from paragraph 46.3 on. There is then an effort to advance reasons, but all of these reasons do no justice to the discretion that has to be exercised, and for this reason. They don't explain how a discretion is exercised to commence an investigation. They list factors that are the result of the investigation and use them as if that is an ex post reason to justify the discretion. But this is, regrettably, a theme of much of the criticism of the public protector that in this report, which is that instead of giving a frank account of the reasons that actuated the exercise of powers when they had to be acted upon, in other words, at the time the discretion was exercised to engage the investigation at all, instead of doing that, there is this effort ex post to say, well, I think there are all sorts of matters of concern concerning possible criminal prosecutions and simulated agreements and the importance of the use of funds and the like, all of which is part of the yield of her investigation, not the basis upon which the power was exercised. And so we say that there has simply been a failure to properly exercise that discretion. And this is the other and last feature of the jurisdictional case, which is just this, that the Reserve Bank has been raising this question of jurisdiction with the public protector throughout. We've never received a proper account as to the circumstances that warranted this warming up of old cold soup, but she has never been drawn until now to try and explain, and when asked to explain, it doesn't appear in a credible form in the report, which is where it had to be reflected. There's an ex post effort to do so in the answering affidavit, but it can't be used in the form that it is invoked because it's ex post, and in any event, it doesn't explain the exercise of the discretion. It just is an invocation of the fact that various things in the public protector's view were yielded through her investigation that ex post warrant the investigation in the first place. Well, if that was the basis for invoking jurisdiction in these circumstances, it would be no discipline of any kind upon the proper exercise of the discretion that Parliament has given the public protector in the relevant provisions of the Act. So we do submit, for those reasons, that the jurisdiction point on this head is good, and if it's right, then of course she could not, in fact, have engaged this inquiry at all, and the report and its remedial actions fail at the first fence. Could I then... Well, the jurisdictional argument would be supportive of the Minister's position that everything needs to be set aside, because if there was an absence of jurisdiction to engage upon the investigation at all, then everything that flows from it must fall with the absence of power to commence the investigation in the first place. Could I come next to a question that was raised by, I understand, by the court, and His Lordship Mr. Justice Puri, I understood, posed this question to my learned friend, Ms. Hoffmeyer, around the declaratory relief in respect of the case that the Reserve Bank makes out concerning the abuse with which this investigation was engaged. And the question was this: is it competent for a court to grant declaratory relief that is separate from the relief that flows from any review grounds that this court should consider warrant relief under PAJA? Is there a basis for a self-standing declaratory remedy in respect of the failure to carry out her office, and doing so in a fashion that constitutes an abuse of office? We have examined the authorities that we could, and there is one authority which we think may be of some assistance to the court. It's the decision of the Constitutional Court in Rail Commuters Action Group and others versus Transnet. It's the and it's reported at 2005 2 SA 359. The relevant passages are to be found at paragraphs 107 and 108, and if I may just read these to the court. It is quite clear, says Justice O'Regan, that before it makes a declaratory order, a court must consider all the relevant circumstances. And this is perhaps the important passage. A declaratory order is a flexible remedy which can assist clarifying legal and constitutional obligations in a manner which promotes the protection and enforcement of our Constitution and its values. Declaratory orders, of course, may be accompanied by other forms of relief. So the Constitutional Court has made it plain that declaratory orders are flexible, they are specifically useful in respect of redress, in respect of breaches of constitutional obligation, and they stand together with other forms of relief. The examples given by the court are these, such as mandatory or prohibitory orders, but they may also stand on their own. And then the court went on to say at 108, it should also be borne in mind that declaratory relief is of particular value in a constitutional democracy, which enables courts to declare the law on the one hand, but leave to other arms of government, the executive and the legislature, the decision as to how best the law, once stated, should be observed. We submit the following. There are causes of action that arise under parja and under the rule of law provisions which impugn the legality of the decisions taken by the public protector and the remedial relief that she ordered. There are remedies that flow from those causes of action. And we know that under parja and by way of constitutional remedy, a review and setting aside are the standard forms of relief that flow from administrative action which is subject to challenge. We know also that declaratory relief can be granted in respect of unlawful administrative action. So insofar as there are causes of action that deal with unlawful administrative action, the court has a full array of remedies. And as we know from all pay, if the court finds